Okay, good morning. Checking the clock. It's still morning. I'd like to welcome Supreme Court Justice Raquel Montoya Lewis, who's joining us online, and Seattle University School of Law Dean and Professor Anthony Verona. Thank you so much. They are the co-chairs of the Washington State Bar Licensure Task Force, and they're here today to update us on what the task force has done, where they are, and what we can expect to come. You'll find in the materials a report that was sent to the court about the task force, which was in fact drafted by our own board member, Governor Williams-Ruth, who served as the co-chair on the task force for some time and is still serving on the task force. So thank you both for being here on a Saturday, and I'll turn it over to you.
Thank you so much. And I will let Justice Montoya Lewis take the lead, since she's a justice and the senior co-chair of the task force. And then I will follow up after she gives us the first part of the update.
Thank you, Dean Verona, and thanks for the invitation to appear today. And I just will also invite Governor Williams-Ruth to chime in at any point, because he was and our chair while I was out on medical leave, and frankly, we would not be where we are in terms of our progress absent his leadership. So I'm very grateful to him and what he's brought to the task force. So I don't want to spend too much time on what you already have in front of you, although that summary, I think, really does a good job of updating all of you with where we are at this point. But I just will give you a little bit of background about how the task force came to be and where we're headed. So the task force was put together following the initial grant by the Supreme Court of diploma privilege during the first summer of the COVID-19 pandemic, and that was a one-time decision by the court. We have not since renewed that, and instead have been, I was asked along with others to put together this task force to look at several things. One was the efficacy of the bar exam in terms of measuring what we hope it measures, and to look at the impact that the bar exam has on marginalized communities. As with all standardized testing, we see a disproportionate impact on examinees of color. And so we wanted to look at that and understand that, as well as understand the history of the bar exam, not just in the state of Washington, but more broadly, and make decisions about what we would recommend to the Supreme Court with regard to leaving things as they are, or adopting or suggesting that we adopt alternatives to the bar exam. And those alternatives, the task force is continuing to look at them very broadly. So one of the things that we've done over the course of the time the task force has been in place has been to hear from the National Council of Bar Examiners. We've had a representative from them on the task force and had an extensive presentation about not just the current bar exam, but what they call the next generation bar exam, which is the bar exam that they will be putting into place over the next couple of years. And I will be attending the National Conference of Bar Examiners conference in May in Nashville. And that conference is a conference where there's one person from every Supreme Court in the country, as well as others from state bars and so on. It's a huge conference in which there's discussion about the bar exam and again looking at efficacy and what's being measured, whether it's measuring the things that should be measured, and so forth. So we have had presentations from the NCBE. We've had presentations from people who have gone through the Canadian system in terms of the articling process. We've also had presentations about licensure in other professions, like the profession of medicine. We've had presentations also from some of our task force members who have done research into other states' approaches to the bar exam. And I know that all of you have had recent information and discussions with Oregon as they have moved forward with alternatives to their bar exam. There are a couple of key things that, as the task force, we try to keep in mind. One of those things is that regardless of what we recommend going forward, we always want to have, I think we're always going to want to recommend an opportunity for people to take the bar exam as it is now, because that number gives them portability. And that portability is important because we don't have, we want to give people the opportunity to be able to practice here and practice elsewhere and take that number with them if that allows them to become a bar member in another state, which was one of the original reasons why Washington went from the essay-based bar exam to this bar exam, because it is a nationally portable number, not to every state, but to many, and gives us some reciprocity. So that's one thing. Excuse me, a little bit losing my voice. That's one thing that we know at this point. We've had many discussions about how to address the history of the bar exam, and that's something that appears in the report, and we've discussed extensively in the task force meetings. The history of the existence of the bar exam is a very difficult and painful history, and largely exists not so much as a licensure process historically, but as a process that is or was a primarily a gatekeeping process. Similar, I think of it similar to poll taxes in the South. There were many times in the history of bar exams, again across the country, but including Washington, where the bar exam was adopted as a means of keeping people out as opposed to keeping people in. And part of our concern as a task force is that while I think it's evident that we're not doing anything intentionally to continue that history, we are without question having a disproportionate impact on examinees of color. And so we are very concerned about that. And there are hundreds of reasons, excuse me, that exist that can explain that history. And I think there are educators who can go into that in more depth than I can. But it is something that we have serious concern about. The other thing, and this is something that I know as a Supreme Court, we've heard extensively from the public and from the Board of Governors, as well as other lawyers, is that the bar exam, I think, is something we all view as sort of a touchstone because it's intended to measure competency. And so we hope that when someone passes the bar exam, that we know that they have that minimum competency. What we don't really know is whether that translates into fewer disciplinary complaints, disciplinary actions, and harm to the public. We don't really have that data. It's difficult because we don't have really a control group. We sort of have that control group now in the sense that we have a group of lawyers who came into the practice of law through diploma privilege 2 years ago, or well, almost 3 years ago at this point. And so I think that as a more long-term project, and it certainly has to be long-term because I don't think we would get any reasonable data from a study this early. But I think in a few years, the court will be interested in looking at whether we see more, less, the same percentage of disciplinary complaints from that cohort of diploma privilege admitted attorneys versus attorneys who took the bar exam. In order to make this a useful study, we would have to certainly look at that with the same cohort of people in the same year, for example, folks that took the bar exam versus folks who were admitted through the alternative process. In terms of alternatives, there are many different approaches that we could take, and we were in the process, and I'd say this is really where our work is going to take us moving forward, is what alternatives, if we choose to recommend alternatives to the Supreme Court, make the most sense for the state of Washington. There are, there's more than one. Diploma privilege is something that exists in the state of Wisconsin. It's been there a long time. If you graduate from a Wisconsin law school, you can be admitted to the bar through diploma privilege. And so we have information from them with regards to the efficacy of that and the safety of the public with regard to the practice of law. That's one approach that we could take. We've also talked about the possibility of something similar to, though not as long, to what the medical licensure program is in terms of working, physicians go into residency. There are examples of alternatives where someone might work with a licensed attorney for a period of time before being able to come into the bar as a fully licensed attorney. Obviously, there's an option to do that under Rule 9, but it's not something that's required. We have talked about that, and Jordan Couch, who's on the Practice of Law Board, has served as our liaison between the Practice of Law Board and the Bar Task Force, has looked at that extensively and is continuing to run our subcommittee with that. A great deal of the work that has occurred over the course of the last year and a half with regard to this, 2 years with the Bar Task Force has really happened in our subcommittees. We have a number of those subcommittees doing research and coming forward with reports and recommendations to the full task force. Over the course of the next calendar year, we anticipate collecting all of that information, putting that together into a larger set of recommendations, and then having some public meetings. And Dean Verona can perhaps speak to this as well, where we hear from members of the public. That includes lawyers, certainly the board, and any others who are interested in participating in the process. We are very interested in getting public comment and hearing from others who have viewpoints on this over the course of the next year before, and we anticipate making a full and complete recommendation to the Supreme Court at the latest by the end of this year. And then we will proceed with whatever the court decides. I think there's a great deal of interest on the part of the justices in this work. They've been incredibly supportive of the work that we've done so far. And I look forward to continuing to work with the task force, Dean Verona, and everyone who has volunteered to give their time and energy to this pretty remarkably extensive project. So I'm very grateful to Dean Verona, to Governor Williams-Ruth, who, as I said, has been absolutely essential to the work that we've been able to do, and the participation of everyone who is on the task force, including Tara Nevitt and many others who have just given us their expertise and their time. So Dean Verona, I'll turn it over to you if you have other things you'd like to add, and we'll go from there. Happy to answer questions as well.
I don't have much to add. Justice Montoya Lewis did an excellent job. I will add my great thanks to Governor Williams-Ruth. He not only lent his leadership to the task force for quite some time during difficult periods, but since I took over as co-chair on July 1, as I stepped into my new deanship, he has essentially served as the de facto vice chair. So he continues to exercise excellent leadership. And as Justice Montoya Lewis said, we would not be where we are now had it not been for his leadership and his energy and very hard work. Justice Montoya Lewis gave you a very good overview of what we've been doing. I've only been involved for the last 6 months. For the first 2 months or so, I focused on getting to know the work of the task force, getting to know my task force colleagues, and starting a new deanship. So I sort of laid low a little bit. But after the first 2 months, so I'd say sometime in September, I offered to be the worker bee organizing force in the leadership of the task force. And so I brought on my Director of Institutional Engagement and Special Assistant to the Dean, Dr. Colin Watron, who's a very, very good project manager. And so Colin has been helping Justice Montoya Lewis and me and the rest of the task force stay very organized and on schedule. So he's applying project management approaches, and we have very specific objectives and goals and a very specific schedule. And as Justice Montoya Lewis mentioned to you, our goal is to spend the next 6 months or so finalizing the reports out from these various committees that we have formed. And so just so you have a refresher on what the committees are, they are research and data, alternatives to the traditional bar exam, lawyer competencies, reciprocity, general equity concerns, NCBE study, history of licensure, and the ethics committee. And so those are fairly self-explanatory. Those are the main areas that we really need to take a very, very close look at and understand and really master before recommending to the Supreme Court any recommendations, whatever they might be. So we are at the final stages of getting reports from those various committees. We are also in the middle of getting very targeted briefings from certain stakeholders that should inform our work. So for example, we will be hearing again soon in great detail from associate deans for international law programs, since the international component is a very important one. We have already discussed some of the international student needs and concerns that we have to take into account as we formulate recommendations. But what we want to do is hear from the three state law school associate deans or assistant deans for international studies, really to understand what we should prioritize as the top concerns involving international students who come to us and then want to sit for the bar. And how the various recommendations might interrelate with that particular cohort of stakeholders. The other thing that we want to do, as Justice Montoya Lewis said, is present the court with preliminary recommendations and then get as much public feedback as we possibly can. So present them to you for your comment and expertise and wisdom, present them to the public so that we could hear from the public, given that the ultimate goal, we think, of attorney licensure is the protection of the public. So we will need to hear from the public. We might have a press conference or two. We will likely have a couple of virtual hearing sessions and might go out to Spokane. So that's what we plan to do during the listening and learning stage of rolling out any recommendations that we adopt. And then at our next meeting, I should tell you, well, let me back up. I was just last week for the entire week in San Diego at the Association of American Law Schools annual meeting. And so we heard there from the NCBE leadership about where they stand with the next gen bar exam that Justice Montoya Lewis referred to. They are on schedule to launch the next generation bar exam in the summer of 2026. As we know, the next generation bar exam is being touted as one that better replicates practice. But there's still a lot of vagueness and uncertainty and not a tremendous amount of information that has been released by the NCBE to us, letting us know exactly what it's going to look like. And it is because they are formulating it now. So it isn't that they're hiding information from us. It's likely that they're experimenting with various approaches and aren't yet committed to one approach. But I attended that briefing for law school deans and other legal ed leaders. It was an interesting briefing, and I could certainly tell you more about it during our conversation. At our next task force meeting in about 2 weeks, we will be hearing from someone else who presented at the annual meeting, the WLS. Justice Montoya Lewis and I corresponded last week, and I asked her if it would be okay to have Joan Hoarth, who is the Dean Emerita and a very distinguished professor at UNLV, come and address us. She presented her new book at the WLS annual meeting. The book is called Shaping the Bar, The Future of Attorney Licensing. It is just published, and so she actually, as a researcher and writer, has done a lot of the research and analysis that we've been doing over the last 2 years. And so I figured that it would be very helpful to have her come and talk to the task force about what she has found, what she thinks the best alternatives are. And it's very interesting that her chapter breakdown is very similar to our list of committees. So that was confirmation for me, at the very least, that Justice Montoya Lewis and Governor Williams-Ruth and Dean Rooksby and the others that have led the task force have really structured it correctly, and we've been looking at the right things. So I think that should take care of the briefing and all the information that we have to share with you. Justice Montoya Lewis and I, and I'm sure Governor Williams-Ruth, want to hear from you any questions, concerns, recommendations at this point that we could take back to the task force.
I have one, Dean Verona. Would it be possible to
Yes.
Get the name and title of that book?
Oh, yes.
So that I can.
Yes, I will. Maybe I could send it to Tara, and then Tara could send it to the. Yes. Okay, good.
That would be great.
And it's an excellent book, and it's on Kindle. And I read it on the way back from San Diego, or started to read it. I read half of it. It's absolutely excellent.
And what alternatives does she suggest?
You know, I haven't gotten to that part of the book.
Oh, okay.
But
Kevin like to cheat.
But yes, but some of the alternatives that she's been analyzing or analyzes in the book, and certainly the alternatives that she's been talking about, are very similar to those that we've been discussing. So supervised practice, diploma privilege, a variation of diploma privilege requiring the completion of certain courses at a certain grade level, so I mean, she gets into, and that's one of the values of this book. She delves into each of the alternatives in great detail. And so we will be here, and that's actually what we're going to focus her presentation on when she comes and speaks to the task force. So it's a very good book.
Right. My concern here, it's not a concern, but the juxtaposition of alternative ways of getting legal education.
Mm-hmm.
We have a relatively unique tutoring program here in the state of Washington, where you can read law, like Abraham Lincoln.
That's right.
Those people have generally a much lower bar passage rate. That's about 50%, is my understanding. But other than the one tutor that they are being tutored by, there is no other gatekeeping mechanism to ensure that there are that people who practice law are in fact competent to do so, or aren't functionally illiterate. So as we get in, I know folks are looking at alternative means of getting legal education. Online, whatever,
hybrid.
The licensing itself is going to get more complicated.
Yes.
As legal education goes from the traditional 3-year postgraduate. And that's what got to deal with. So I'd be interested to see how that plays out, given what other folks, including our practice of law board, is considering in that area.
No, it's a very, very good point. You raise a very, very good point about whether there should be alternatives available to those candidates for bar licensure who have not pursued a traditional educational path. So that is something that we should definitely add to the list of what we need to tackle. Thank you.
I just want to add one thing with respect to the diploma privilege that we did in 2020. That only applied to graduates of Washington accredited law schools. So it's people who are preparing to take the bar exam that had LLMs, for example, or that were coming out of our alternative program, were required to take the bar, largely for the reasons that Governor Fay just raised, in terms of we wanted to be assured that the education they received was an education that was accredited by the bar exam and had been measured by the law schools. So we weren't in a position at that time, didn't feel we were in a position at that time to recommend that completion of, as you described it, the Reading the Law program. The completion of the law clerk program was a program that would give us the information we needed with respect to admission, because it varies so greatly from tutor to tutor. I served on that board. I also have served as an assistant tutor in a couple of instances. There are people in that program who are working with multiple assistant tutors, so they're getting all kinds of perspectives, education, and background. And then there are others who don't have the access and who are just working with a single attorney supervising them. And I think that there's just a wide range of what education they get. And so we weren't comfortable at the time of the diploma privilege, without knowing more information, of granting them admission. So they did take the bar exam. And I agree that there is a marked difference between bar passage rates between those individuals who complete the law clerk program. But we don't really know why. And the cohort is so small that it's difficult to put a lot of weight onto to that bar passage rate. And so I just want to caution us as we go forward to remember that when we're looking at that, for each bar pass list, so sometimes we have one or two people, and so that number of or the percentage of people that pass is concerning, but it also is a very small number of people. So, and Dean Bruno, I can't see people in the room, so I'll just let you call on people. I see a couple of hands virtually too.
Anyone else?
Okay, I think I'm next. I just want to add a couple things. One, as we're thinking about looking at these recommendations in the future, I just want to kind of remind us what our role is. So ultimately, the court will be the decider in this. And ultimately, WSBA will be largely the implementer of most of these decisions. And so I think it'll be really important when we get the recommendations to be looking at them through that lens and contributing our expertise about how these might be carried out and questions we have about how they might be carried out, so that we can make sure that those inform the recommendations. The second thing I wanted to add is that although most of the focus is on alternatives to the bar exam, one of the other topics that we can expect to get recommendations about is the character and fitness process. So I just wanted to make sure that was also part of the conversation.
Oh, yes. Yes. And Governor Williams-Ruth actually has been leading a big part of that effort.
Thank you. And actually that was, I want to extend great appreciation to everyone on the task force, Justice Montoya Lewis, Dean Verona, and Tara, Hanada, Julie, the people who have helped with the research, the backside of where we're going. Without everyone on the task force, it would not have been able to get where we are. I'm excited for Dean Howarth to come. Spoiler alert, she and I had connected and she did send me chapters 9 and 10 of the book before it was published. So because I am the coach, or I am the chair of the ethics subcommittee, which is dealing with character and fitness. And so the work that this task force is doing, and Governor Couch, I wish he was here, because I'm really focusing on the character and fitness. And so I have been able to attend multiple conferences with leaders from across the country on the issues regarding this. And the task force back in 2022 did adopt a outline for delineated changes to the character and fitness process. So that subcommittee is already in the drafting stage. And by the way, if there's anyone on here that happens to have some qualified associates or maybe law students that want to help with the academic writing for this wonderful, persuasive report that'll be submitted to the court, please let me know. But also, just to give everyone context, when what Dean Verona was talking about in terms of the, as I like to call it, the dog and pony show, that was something I recommended based off of what Director Nevitt and past President Shiketti and Majumdar had done with the listening tour. That was an idea that I had brought to the task force as the base, saying how much is gained in reaching out to areas beyond the people in this room, the people in this in the downtown core, and that's really where many members of the task force are committed. Once we have a product that's going to go public, and Dean Verona and Justice Montoya Lewis have presented it to the public, then there's going to be a real concerted effort from people from all of the various constituencies on the task force to bring it back to get the summer of information. And so as you see those coming up this summer, please do reach out. Let us know if you want to have an event in your area, especially for people outside of the Seattle area. Let me know, because again, I have committed my time to helping make sure that we get the feedback, we get this out to our members, and that we engage in a conversation. I have already, after the last BOG meeting where this task force was featured as talking about today's meeting, I'd already received multiple emails of people who have thoughts and concerns. Some are not really wanting to engage. They just want to shout into the void, change nothing, change nothing, change nothing. And I say, okay, do you want to talk? No. Okay, well, thank you. I have noted this, and we go forward. The hope is that there will be actual conversation, because I will say what I knew 2 years ago was based on my experience having served on the Character and Fitness Board and then served on this board. And now my horizons have been broadened beyond anything I knew I didn't even know. So again, I'm just so grateful for the court, for Justice Montoya Lewis, for Dean Verona, and for everyone who's taking time, because there are about 25 or so practitioners, academics that are out there, and everyone. I mean, and I know past President Shiketti is listening, and so I'm probably going to get a text, but the people from Oregon have been amazing. Dean Galini from Willamette University, before Dean Verona came on, he talked with me, and it's been a very collaborative process across so many different channels that I'm excited for what the final product will be.
Thank you, Brent. I'm going to go next to Hunter.
All right. Thank you, Justice Montoya Lewis, and thank you, Dean Verona. Yeah. I have a comment that President Clark has asked me to read. I would like to emphasize my hope that whatever alternatives are adopted, that the APR Rule 6 law clerk applicants be treated equally. I would also like to point out that Rule 6 were denied diploma privilege despite a unanimous resolution from this Board of Governors urging that they be included. They were further denied diploma privilege despite a letter of reconsideration from past President Majumdar and a letter from the law clerk board urging inclusion, and a subsequent letter for reconsideration, also supported by this Board of Governors.
Huh.
Thank you.
Good to know. Anybody else? Yes, yes, sir. I'm sorry, I can't read your.
Hi, I would just also like to thank Justice Montoya Lewis, Governor Williams Ruth for your hard work, and Dean Verona. We appreciate you being here on a Saturday. I would just like to reiterate the comments about law clerks. I am a law clerk. I'm told that I'm the first law clerk to sit on the Board of Governors. I
Ooh.
don't know if that's true, but one of the things that I would like to add, and I hope I'm not being redundant, is that when I took the bar exam, I was the only one out of 8 to pass. So, and I've
Wow.
paid attention to the pass rates over the years, just out of general curiosity, and those numbers seem to reflect similar percentages. I will say that I had a very experienced mentor, and I had the experience going into the bar exam. But as far as the bar exam itself and what, if any, changes are needed to be made, because certainly I would agree it is a archaic process and to some extent, would just be to consider those like me who didn't go to law school, who didn't, will never be a jurisprudence recipient, and that when the diploma privileges were granted for law students, it was disappointing for me because I know how much hard work our law clerks put in, and it's not necessarily a program that is not regulated. Certainly the Bar Association regulates that program and makes the determination to see if those law clerks are eligible to receive their WSBA diploma, as I call it.
Yeah.
And so when, again, just at the risk of sounding redundant, it's important that the considerations that are made as far as the bar exam consider people like me. And it seems to me the hesitancy for law clerks has more to do with character and fitness versus actual knowledge. And I would agree that there's alternatives out there, but we are lawyers too.
Yes.
So, and I would be interested to know if there's any upcoming meetings or need for input, because I certainly would be willing to offer my
Good.
experiences to the committee. But again, I just want to thank everyone again for presenting on this issue.
Well, this is a very important issue, and we will take your comments back to the full task force. And I'm sure that we will be discussing this particular topic and making sure that we work it into any recommendations that we might deliver to the court. But thank you for raising these important issues. Yes, sir. Governor Endy.
Maybe someday. Currently Chief Disciplinary Counsel, MD.
Endy.
My question, and I want to ask it now because you're still at a relatively early phase of this process, is whether the task force is or maybe would consider the relationship between admissions processes in Washington state and a larger issue of admissions nationwide. And the question I suppose is, in this era of this 21st century where there's a great deal of mobility and cross-border presence electronically, and borders are kind of becoming more and more meaningless to the practice of the profession. Does it make sense? Does it continue to make sense for Washington state to do its admissions processes this way or that way? How maybe we'll do them eventually, and Oregon to do its admission processes their way, and Montana to do it their way and New York to do it their way. And you can see what I'm saying, the patchwork of everybody doing this a different way. And it's my hope, and I'm not asking the question because if you're not thinking about this, shame on you, you need to consider it. But I think it's out there, and work is being done in the area of cross-border and multi-jurisdictional regulation that maybe shouldn't be siloed from the inquiry about admissions. Does that make sense?
Well, it makes absolute sense. And actually similar comments were raised at the NCBE session at the Association of American Law Schools annual meeting. So you are onto a very important subject of whether the way that we assess licensure competence is anachronistic and protectionistic and way too balkanized at the state level. When we all have to swear allegiance to the United States Constitution, right? Isn't there some sort of cross-border interstate aspect to all of this that we have to take into account as we go forward as licensing agents? And so some of this energy went into play with the NCBE's adoption or proliferation of the MBE, of various interstate common portability promoting measures. But I think you're absolutely right that the opportunity for some of the states like ours to really take a deep dive into licensing standards, licensure standards, have begged this broader question of why it is that we're doing this at the state level in such a balkanized way. So I do think you're onto something very important. And I'm not sure that the task force is set up and charged with solving that particular problem. But I do think, right, Justice Montoya Lewis, but I do think that your very important broader question is one that merits contemplation.
Hey,
Anyone else?
There's two, a few more hands. There's one online with 1425 and then 977s.
Thank you, Governor Clark.
Hi, it's Michael Cherry, Chair of the Practice of Law Board.
Great.
And I just wanted to echo on what Doug Endy said about the interjurisdictional practice. The number one complaint we probably get under UPL are complaints from lawyers complaining about lawyers from adjacent states practicing in Washington. And it's highly misunderstood. Both by the people who come into practice and the people who are complaining about it. Secondly, I'd like to just say, Practice Law Board is also bringing to the Supreme Court a series of processes for data-driven legal regulatory reform. Sometimes it's called a lab or a sandbox. But I'd just like the committee to be aware that we're trying to put in place some processes that the committee might be able to use to actually, instead of just think about what an exam might look like, sort of as a whiteboard or a theoretical exercise, we're trying to put in place a platform and processes that would allow you to test different exam types, collect data on them, and so we could actually make data-driven decisions about what the next bar exam should look like. So, I encourage you to look at the work that the Practice Law Board is doing in this area of data-driven reform, and maybe we can work together on something because we're trying to design this in a very open method such that it could be applied to a variety of different things. Thank you for your time.
Thank you. That's fantastic. I think Justice Montoya Lewis and I should definitely follow up with you. I love this idea. And yes, we shouldn't be working in silos. Sounds like we have a lot of common interests and we could work together very productively.
And I'll just add to that the Practice of Law Board came to our temporary space. The Supreme Court Temple of Justice is being renovated. And so we are in a new temporary space, although we'll be there for a couple of years. So I don't know how temporary it really is.
Interim.
But the Practice of Law Board came to give a presentation on that work at the last en banc meeting of the court. And in fact, that was the first formal meeting we hosted in our new space. And so it was very nice to have the the board there. But I absolutely agree. There's a great deal of crossover in terms of the thought process behind what the work of the Practice of Law Board is, as well as in terms of the work that the task force is doing. And to a certain extent, I think, it's sort of the work that they're doing is very much a follow-on to the work that we're doing, because they're really talking about the practice and the way that practice gets regulated. And they shared with us a lot of information about the way legal work is getting packaged nationally. And there was a great deal of information there that was information that that was somewhat new to me with respect to some of the technological advances that have led to much more cross-jurisdictional practice, and what constitutes practice in a state, for example, raise a lot of really important threshold questions that are only going to get more complicated as our technology develops. And I think it is crucial that we hear from them, and we have heard from Governor Couch extensively on the work that the Practice of Law Board has done, and he presented about the sandbox, which is sort of the shorthand, I guess, of the work that the Practice of Law Board has been doing a couple of times. So and he's been also just invaluable as a participant. And I absolutely agree that we can be working together on all these questions. And I do think that these are going to be questions that, regardless of what we do with the bar exam, are going to be questions that WSBA and the Supreme Court are going to have to address, because we're just going to see more and more of these questions come up.
Yeah.
Okay,
Other
there's
thoughts,
still-
advice?
Yeah, there's still one hand up by Kevin. Okay.
I just wanted to follow on with what Doug Endy talked about, the multi-jurisdictional issues. Although I just want to point out that the multi-jurisdictional issues go beyond the 50 United States. There are multinational companies in this country.
You're absolutely right.
I had the opportunity when I was working at a large software company based in Redmond to work with Horacio Gutierrez, who had a law degree from Venezuela, which is a civil law country. Hold that in your mind. He got an LLM from Harvard Law School, which entitled him to take the bar in New York, where he passed. He would not be qualified to take the bar in Washington State. So at the time that he was running Microsoft's legal department across Latin America from Miami, in order to be admitted in Florida, he had to go to law school at night, even though he was teaching a class at the same law school. And until he got that JD, he would not be eligible to practice law, to even sit for the bar to try to practice law in Washington, which is why Microsoft did not bring him here until he had that.
That's right.
Horacio is now the general counsel of the Walt Disney Company.
Yes, and he's a good friend of mine.
Oh, well, there you go. We had another guy, Renaud Westerdijk, who had been a practicing attorney in the Netherlands, a civil law country. And he had to suffer as a legal assistant at Microsoft Limited in what they could pay him because he was not eligible to sit for the bar, which through, I don't know the mechanism, he ultimately passed and is now a licensed attorney in the state of Washington. So among, there possibly has to be some sort of gatekeeping. But if you make it a good gatekeeping, an efficient one that can separate the competent from the non-competent, you can vastly open up the ways that people get their legal education.
Absolutely.
Because there are lots of great lawyers in the world, and there's a lot of international movement. And goodness, any Canadian lawyer can get a TN visa to work in the United States. They have to, can they sit for our bar? Yes, they can under certain. So I
can't
think
agree
that
with-
needs to be taken into account
pardon
as
me.
well.
I cannot agree with you more. And Horacio Gutierrez is such an excellent example of exactly what that challenge is. You're absolutely right. He earned his LLM from Harvard after he graduated with high honors from a law school in Venezuela and had been practicing law as an international lawyer at the highest level. And then earned his JD. That's right. That's right. And he was general counsel at Microsoft, earned his JD as a part-time student at the University of Miami. After that, I got to know him. He was one of our donors. And I'm actually trying to get him to speak here at Seattle U Law. But he's a perfect, and now absolutely, he's the general counsel, executive vice president for Disney. So he's an excellent example of somebody who falls through the licensing cracks, particularly when the licensure substrate is insular and not particularly open to international lawyers in a way that it should be. So this is something that we have to address. And one of the reasons why we are having associate deans for international programs come talk to us, either at the next meeting or the meeting after that. I think Dean Howarth is talking to us at the next meeting, and the international folks are coming the meeting after that. So we will make sure to address this particular problem. Thank you.
I'd like to be involved if that's possible.
Sure, I would love it. We would love it. Yeah, good. Anyone else?
Okay, I see no hands up, so thank you.
Thank
so
you very much,
and-
Mr. President. Thank you. Thank you. And Happy New Year. I don't know if we've reached the point where we go from friendliness and charming Happy New Year greetings to creepy, too late. But Happy New Year to everybody.
Thank you so much again. Okay, we had a late add on to the agenda. I'm sorry for this. It's late material, but I'll try to
So the late item is that we wanted to wish a happy birthday to our treasurer, Francis Adewale.
I object to every late materials.
And the very late materials are right here in this envelope.
So it's okay if it's the late, it's okay if it's your birthday.
You had my objection, Mary.
I'm
Thank
still
you,
not
everyone. I
I'm
love
still
this
not
watch.
getting you a gift card.
Thank you. I just wanted to express my gratitude to this board. You all have been more than a friends. It's been amazing serving with you all, and I'm grateful to you all. Thank you.
Mr. President, if you don't mind, join me, governors. Happy birthday to you. Happy birthday to you.
Happy birthday, dear Francis. Happy birthday to you.
And may I say, I mean, so we did way better now than last time, the last meeting for Shelley. So
Shelley's laughing.